Thank you everyone for joining us today. My name is Awista Atkins. I am the Training and Development Coordinator at the Native Learning Center. On today's virtual training, we do have Crystal on as well. She will be also monitoring the chat with me. So if you have any questions, please go ahead and put them in the chat box. If you are joining us from the web browser, we have noticed that there are more technical difficulties if you are on the web browser versus if you are on the app. So I would go ahead and take the time to download it if you can, or later on download it for tomorrow's virtual training. I do ask for those of you who are joining us or coming into the room, just please make sure that you are on mute while Cheryl is presenting. You should have access to your mic. With that being said, I would just be very careful while Cheryl is presenting so that way we can hear everything she is saying. If you are joining us and you're sharing a screen with somebody, please enter your first and last name in the chat box as well, so that way we know who is here today. And with that being said, today is Admissions and Occupancy Day 4 on September 29th. Cheryl, would you like to take it away?
Thank you so very much, my girl. So, as she said, today is Day 4. This presentation is courtesy of the Native Learning Center. Welcome and good afternoon. I did go and smudge on our behalf. I'm very thankful that everything went through Florida and it went easier than they thought it would for most. So that's a good thing. Here is my information should you need it, and it's found also at the end of the presentation. This webinar is being recorded. This is my information, but I've gone through it for 3 days, so I'm going to skip it today in the interest of time. We didn't quite finish the section on calculating adjusted income yesterday, and we've got quite a few sections today, although they are short ones. So hopefully we can get through the majority of it, maybe all of it today. So I'm sorry, we're going to start off with having to complete Day 3. It's a necessary component. So Section 5 is calculating adjusted income. And to determine the total tenant payment, so if you ever see that TTP, that's what that means. For monthly rent, home buyer payments, the staff has to determine the household's adjusted gross income and then the monthly adjusted income. That total tenant payment is based upon a percentage of the adjusted income, which is defined as the annual income that remains after you exclude the following amounts in accordance with Section 4 of NAHASDA. The statutory definition is as follows. The following described allowances are applicable regardless of which definition of income is utilized. So that means you should be offering all of these allowances if they apply to your tenant. Adjusted income. The term adjusted income means the annual income that remains after excluding the following amounts. Youth, students, and persons with disabilities. $480 for each member of the family residing in the household other than the head of the household or the spouse of the head of the household. Or, that co-leasee. So those, 3 positions at the very top, a lot of things are going to apply if you're dealing with them. Okay. So, who is under 18 years of age, who is 18 years of age or older, and a person with disabilities or a full-time student. So then you can have an additional, okay, so that's the definition of youth, students, and persons with disabilities. Elderly and disabled families are $400 for an elderly or a disabled family. And we're going to touch on these all a little bit more, okay? Medical and attendant expenses. the amount by which 3% of the annual income of the family is exceeded by the aggregate of medical expenses in the case of an elderly or a disabled family, reasonable care and auxiliary apparatus expenses for each family member who is a person with disabilities to the extent necessary to enable any member of the family, including the person with the disability, to be employed. Child care expenses to the extent necessary to enable another member of the family to be employed or further his or her education. Earned income of minors, the amount of any earned income of any member of the family who is less than 18 years of age. Travel expenses, excessive travel expenses not to exceed $25 per family per week for employment or education related travel. So $1,300 a year. Other amounts, such other amounts as may be provided in the Indian Housing Plan for the Indian tribe. So your governing body, whether it be your tribal council or your housing board of commissioners, if they decide that they want to offer an additional deduction, they have to do so in a duly called meeting, make sure it's reflected in the minutes, and then include it within your Indian housing plan. Okay. So the allowance for dependents, each dependent, $480 must be deducted. A dependent is any household member other than the head of household or the spouse who is under 18 or who is 18 years of age or older and a person with disabilities or a full-time student. Some family members may never qualify as a dependent regardless of age, disability, or student status. The head of the family, the spouse, and the co-head may never qualify as a dependent. So remember, those are the three positions you always have to look at. Are we talking about one of these three people? Spouse, co-head, the head of the family, the spouse, or the co-head. And that's what they refer to them as, a co-head. A foster child, an unborn child, a child who has not yet joined the family, or a live-in attendant may never be counted as a dependent. Now that's the one that surprises a lot of people, that you cannot give that dependent deduction to a foster child.
Yeah.
Okay, somebody needs to mute. Family sharing custody deduction, when one or more of the family shares custody of a child, and maybe both sets are within your housing, only one family at a time can claim that dependent deduction. The family with primary custody at the time of the initial certification or the annual recertification would receive the deduction. If there's a dispute about which family should claim the dependent deduction, you should try to go to a valuable document such as court orders and perhaps their IRS return showing which family has claimed that child for income tax purposes. You have to, make them come upon an agreement or whatever, but because you can't give it to both of them. Elderly and disabled deduction. A $400 elderly or disabled family deduction should be allowed only if it's the head, the co-head, or the spouse. Okay. Now they have to be in one of those three positions, and even if they've got mom living with them that's 80 years old, unless she's in one of those three positions, you can't count that as an elderly household. The term person with disabilities is defined by 24 CFR 1000.10, and it means a person who has a disability as defined in Section 233 of the Social Security Act, developmental disability as defined in 102 of the Developmental Disabilities Assistance and Bill of Rights Act. It's expected to be of a long, continued, and indefinite duration, substantially impedes his or her ability to live independently, is of such a nature that such ability could be improved by more suitable housing conditions. The term person with disabilities includes persons who have a disease of the acquired immune deficiency syndrome or any condition arising from that etiologic agent for acquired immune deficiency syndrome. So
He was part of
your disabled person is supposed to also be one of those three people. The head, the co-head, or the spouse, okay? Not the son. So there's very, definite rules there. Notwithstanding any provisional law, no individual should be considered a person with disabilities for purposes of eligibility housing assistance under this part solely on the basis of any drug or alcohol dependence, okay? For purposes of this definition, physical, mental, or emotional impairment does include, but is not limited to, psychological disorders, conditions, cosmetic disfigurement, and a lot of loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic, lymphatic, skin, and endocrine. Any mental or psychological conditions such as mental retardation, organic brain syndrome, emotional or mental illness, specific learning disabilities. The term physical, mental, and emotional impairment includes, but is not limited to, such diseases and conditions as orthopedic, visual, speech, and hearing impairments, cerebral palsy, autism, epilepsy, muscular dystrophy, multiple sclerosis, cancer, heart disease, diabetes, human immune deficiency, virus infection, mental retardation, and emotional illness, excuse me. Okay, so your elderly and your disabled deduction can be used to determine when a live-in aid attendant is necessary. That definition will also be used to determine whether applicants are eligible to deduct their medical and attendant care expenses from their adjusted income, which in turn will affect their monthly payments. The deduction is a household deduction only. If the family is an elderly couple, only one $400 per household deduction would be allowed. The other considerations: receipt of Social Security disability benefits, supplemental security disability benefits does qualify an applicant to be a person with disabilities. Receipt of a government benefit or private disability benefit, such as workman's comp, does not always qualify that applicant to be a person with disabilities. Receipt of Veterans Administration disability benefits or other disability benefits does not necessarily meet the current definition of a person with disabilities. An individual is not considered to be a person with disabilities, again, solely based on any drug or alcohol dependencies. Your medical and your attendant expenses deductions, according to NAHASDA, medical expenses are deductible for elderly and disabled families only to the extent that gross annual income of the family is exceeded by 3% of the gross annual income. The expenses could include medical expenses in the case of an elderly or a disabled family, and reasonable and attendant care, auxiliary apparatus expenses for each family member who is a person with disabilities, to the extent necessary to enable any other member of the family, including the member who has the disability, to be employed. Medical expenses can only be deducted if they are paid for out of pocket by the family and not reimbursed by an outside source such as insurance, Medicare, grants, Indian Health, state agencies, or other charitable organizations. They are anticipated to be paid by the household in the next 12 months following the date of certification or recertification, and it's up to you as a recipient to define medical attendant care and auxiliary apparatus expenses in your admission and your occupancy policy. Exhibit 5.1 identifies the rules used under 24 CFR Part 5. So this is the exhibit. Attendant care and auxiliary apparatus expenses may be allowed if they're necessary to enable a family member, including the person with disabilities, to be employed. Anticipated to be paid by the household in the next 12 months following the effective date of your recertification or certification. Not reimbursed by an outside source, such as insurance, Medicare, grants by state agencies, charitable organizations, but in our case, Indian Health falls in here. Not paid to a family member living in the household. Auxiliary apparatus includes, but is not limited to, wheelchairs, reading devices for visually impaired, equipment added to cars, vans to permit their use by the handicapped or disabled family member. So your medical and your attendant expense deductions, examples of medical expenses include services of physicians, other healthcare professionals, services of healthcare facilities, medical insurance premiums, including the Medicare premium, prescription, non-prescription medicines, transportation to and from treatment, dental expenses, eyeglasses, hearing aids, batteries, attendant care, periodic medical care, and payments on accumulation of medical bills. So how is that adjusted income calculated? Adjusted income is derived by subtracting any of those 5 deductions or allowances that apply to the household from the household's gross income. The household's eligibility for deduction depends in part on what type of household it is. Not all households are eligible for all the deductions. Exhibit 5.2 summarizes these deductions by household type. So, you would, if you had an elderly and disabled household, you would be qualified for every deduction. If you just qualify as a family, dependent deduction, childcare deduction, and disability expense deduction, you would not get to deduct the medical expenses. So elderly and disabled households, as noted in 5.2, a household's eligibility for adjustments to your annual income depends on, in part, whether the household qualifies as an elderly household or a disabled household, or a family non-elderly household. An elderly household is any household in which the head, spouse, or sole member is 62 years of age and 2 or more persons who are at least 62 of age live together, or 1 or more persons who's 62 or older and lives with 1 or more live-in aides. Exhibit 5.3 provides examples of your elderly households. Each of these are considered elderly households. Alice is 65. She lives with Joe and he's 60. Juan is 69. Rosa is 63. They live together. Jane is 92. Thomas Miller is 74 and he lives with his live-in aide. They are all considered elderly households. A disabled household is one in which the head, spouse, or sole member is that person, or co-head, is that person with those disabilities. 2 or more persons with disabilities living together and 1 or more persons with disabilities living with 1 or more live-in aides also qualify as a disabled household. The following examples in Exhibit 5.4 are considered disabled households. Carlos is 25 and he's disabled, so you can live by yourself. Fred's 42, his wife Suzanne is 41 and disabled. They're a disabled household. Daniel is 35, he's disabled. He lives with his housemate Charlie, 38, who is disabled, and their live-in aide. Those are all disabled households. Certain households may, however, include elderly and disabled household members and still not qualify as elderly or disabled households. For example, neither of the following households qualify as elderly or as disabled household. Bob and Carol are 50 and 49 respectively, who have taken Bob's mother, age 70, in to live with them. Because Bob's mother is not on the household head, co-head, or spouse, this is not an elderly household. Ted and Alexis, both 35, have a son who is 14. He is disabled. Because the son is not the household head, spouse, or co-head, the household is not a disabled household. Exhibit 5.6 illustrates a family who is eligible for a combined deduction for both disability assistance and medical assistance. Special calculation for families who are eligible for disability assistance and medical expense deductions. So the head of the household is retired and disabled. Social Security pension income of $16,000. Spouse is employed. Her employment income is $4,000. Their total annual income combined is $20,000. Total disability expenses are $500 a month. Total medical expenses are $1,000 a month. Determine if the disability assistance expense exceeds 3% of the family's total annual income. So their total disability assistance expense is $500 minus 3% of the total annual income, 0.03 times that 20,000, it comes out to $600. So $100, so no portion of that disability expense exceeds 3% of annual income. Therefore, the disability assistance deduction in this case would be 0. Calculate the medical expenses to see if they exceed the balance of 3% of the family's total annual income. Their total medical expenses are $1,000 minus the balance of 3% of the total annual income, which is the 100. The allowable medical expense deduction would be $900. So we also have an allowance for childcare expenses. You need to write a policy for this. Your childcare expenses are defined as the amount to be anticipated to be paid by the family for the care of children, which can include, in this case, foster children, during the period for which annual income is being computed. Child care is only deductible while such care is necessary to enable a family member to be gainfully employed or to further his or her education. Okay. Volunteering someplace does not work. It's an employment or school. It's up to your policies to determine under what age, if any, children must be to be eligible for a child care deduction. So you'll see, people will pay that up to a 12-year-old or a 13-year-old. You have to write, and a lot of times, they will write it that child care has to be provided during the same hours while the person is at work. You can't go to work from 6 o'clock until midnight every night waitressing and take childcare from 8 in the morning until 4 while you're home. So you got to make sure that you have a policy for that. So your suggested rules for childcare allowances: deduct the childcare expenses if the amount deducted is reasonable. If childcare enables a family member to be gainfully employed, the amount deducted should not exceed the employment income. So you can't charge $2,000 in a quarter for childcare and make $1,000. Okay. The amount is not paid or reimbursed by any other agency or individual outside of that household. Suggested rules for your child care allowances. Child care expenses incurred to permit a family member to work must not exceed the amount earned by the family member made available to work during the hours for which child care is paid. Do not deduct if child support payments are for children who do not live in the unit. If expenses are for the care of persons with disabilities who are older than the age determined by your policy, and if the individual or organization providing child care also cares for other family members, make sure you prorate the total cost and allocate a specific amount for the care of the children under the age that you set in your policy. Example language: Childcare expenses are the amounts anticipated to be paid by the family for care of children under the age of 13 years of age during the period for which annual income is computed, but only where such care is necessary to enable a family member to actively seek employment, be gainfully employed, further his or her education, and only to the extent such amounts are not reimbursed. Reasonable expenses, the amount deducted shall reflect reasonable and verifiable charges. Conditions, the child care must be necessary to permit the employment or education. The amount deducted shall not exceed the amount of employment income that is included in annual income. The amount deducted cannot result in no house payment. Child care expenses do not include child support payments made to another on behalf of a minor who is not living in the assisted family's household. Child care expenses for foster children that are living in the assisted family's household are included when determining the family's child care expense. If the child care expenses being claimed, can somebody mute their microphone? If the child care expenses being claimed is to enable a family member to further his or her education, the family member must be enrolled in school, academic or vocational, participating in a formal training program. The time spent in educational activities must be commensurate with the child care claimed. If the child care expenses being claimed is to enable a family member to be gainfully employed, the family must provide evidence that the family member's employment is during the time that the child care is being provided. The earned income used for this purpose is the amount of earned income verified after any earned income disallowance or income exclusions are applied. When the child care expenses being claimed is to enable a family member to work or obtain an education, only one family member's income will be considered for a given period of time. When more than one family member works during a given period, the ATIHA will generally limit allowable child care expenses to the earned income of the lowest paid member. Okay. Non-eligible child care expenses for school-age children, cost attributable to public or private school activities during standard school hours are not eligible. Expenses incurred for supervised activities after school or during school holidays, summer day camp, after school sports league are allowable forms of child care if they enable a household member to work or further their educational pursuits. The cost of general housekeeping and personal services are not eligible. Child care expenses paid to a family member who lives in the family unit are not eligible. However, payments for child care to relatives who do not live in the house are eligible. So that's sample. Earned income of minors, this allowance excludes any earned income of any members of the families who is less than 18 years of age. Excessive travel, this allowance is for the benefits of families who must travel long distances to and from work or school. It's important to remember this allowance can only be allowed for excessive travel for employment or education purposes. The allowance must be reasonable, may not exceed $25 a week for the entire household, not per traveler. $1,300 per year max. You need to set what your excessive distances. So our distance to town, depending on where you're on the res, could be, 20 to 27 miles. So we set 20 as an excessive, so they could go to the college in the following, in the sister town, or they could work in there. So we use 20. And then you can ask for like a Google map. Example languages for excessive travel, documentations, family requesting an allowance for travel to work must document that they are traveling, in this case, 25 miles or more daily. The following represents, but is not limited to, information that the ED might require: a mileage log, a Google map, home to work, work verification, or a vehicle registration that you have a licensed vehicle to do that. You can't be drawing that allowance when you don't have a vehicle, you're bumming a ride with somebody. So other amounts, the recipient may determine and define other allowances that can be deducted from your family's income. They should be included within your admissions policy and the Indian housing plan. You have to be able to show where your board approved that allowance. And you should have where you could see the impact it's going to have on your housing budget. They just want that due diligence to make sure that, you're not losing huge amounts of your subsidy. So your total tenant payment, your TTP, is the amount a tenant is expected to contribute for rent. The TTP for NAHASDA assisted programs is typically calculated based on a percentage not to exceed 30% of adjusted gross income. Some programs provide a utility allowance, which is subtracted from that total tenant payment, leaving that amount equaling the tenant rent. It's possible for a tenant rent to be zero if the utility allowance is greater than their total tenant payment. First of all, we do not need to give utility allowances anymore. And the second thing is you should write your policy that if there is a negative, that there's no such thing as a negative rent under any circumstance, okay? You don't want to be paying people to live in your units, but you always have to make sure that you're not charging them over that 30%. So calculating tenant rent with the utility allowance, based on monthly adjusted gross income. The annual income is $21,000. Their deductions are $960. Their adjusted income is now $20,040. The adjusted monthly income, $1,670 times that 30%. So their total tenant payment would be $501. You're going to subtract the utility allowance of $84. Their total tenant payment would be $417. Okay, so some computation issues. Section 203 of NAHASDA states that the rent and home buyer payments for low-income families cannot exceed 30% of that family's monthly adjusted income. You may choose to use a lower percentage of adjusted income for calculating house payments. I've seen in some cases where, it's an elder community or it's elder housing and they charge them 15 or 20%. A sample expert from an admissions and occupancy policy is provided in Exhibit 5.8. So we're going to come to that. A flat rent in accordance with 24 CFR 1126. You can now charge a flat or income adjusted rent or home buyer payment, provided that that rent does not exceed 30% of the family's adjusted income. That's the bottom line. That's the bottom line on what you charge people. That's the bottom line on how often you recertify them. You have to have a mechanism in place to assure that nobody is paying over 30% if they fall at your 80% line or less. Now, if they make more, you can charge them more. But if they're below or at 80%, you can't do that. And you have to make sure that you convey that when you move them into a unit. Should you experience that reduction in income, you call us, you come in and see us, you do something, don't be embarrassed. We're here to serve low income people. So make sure you know that, because if they ever do an audit and they find that out, they'll make you go back. I've seen them go back and make them do every tenant file back for a number of years, like a 4 or 5 year period. And then if they were overcharged, they have to pay that money. So don't do that. So rental payments for low rent housing for seniors. This is that sample. Gross annual income will be defined by Section 8. So it tells you how they're going to define it. Rents will be based on 15% of adjusted gross income for that household. Gross annual income will be adjusted by the following. We're going to give you $480 for every dependent, documented childcare up to $1,200 a year, utility deduction up to $1,000 per year, an elderly deduction $400 per elderly household that uses that home as their principal residence. They might have snowbirds in this area. Per capita payments of the tribal members if there is enough income to meet the minimum payment requirements. So in this case, it must be a per cap tribe, and they're going to waive that as long as, they're paying something. So, And you have to make sure that this is, adopted by your tribe, and it's in your IHP, and it's in your, admissions and occupancy policy. So less than 30%. If you choose to charge less than 30% of adjusted gross income for all families, less income will be generated to operate your housing program as a business. In this instance, the recipient may need to find other income to fill that gap or reduce your operating expenses. This also applies when the recipient charges lower rates for your elderly, disabled, veterans, regardless of what percentage is used, your occupancy staff will have to calculate the monthly rent or house payment. Today, many housing programs use computerized systems that compute rent and house payment calculations based on that definition of income that is adopted. It's important to remember that after deciding on the definition of income that is to be used, the exclusions from income apply as defined through NAHASDA and 24 CFR Part 1000. So when are you considered low income? There's different times depending on the program that you're in. Family is considered low income if they're low income at the following times. In the case of rental housing, when they are initially occupying that unit. That's why it's so important that if you pre-qualify them, yep, you're eligible for our programs, yep, you're on the waiting list. If that information is more than 30 days old, recalculate it all again, because you have to keep proof of eligibility on admission, okay? In the case of a contract to purchase existing housing, it's at the time that you purchase that household. You have to be income eligible. In the case of a lease purchase agreement for existing housing or for housing to be constructed, it's the time the agreement is signed. In the case of a contract to purchase housing that's going to be constructed, at the time the contract is signed, if the person subsequently becomes non-low income family due to an increase in income, the family may continue to participate in the program in accordance with your recipient's admission and occupancy policies. So make sure if that's what you want to happen, if that's how they read. So calculating that assistance without HUD approval, you put it in your IHP. You should have a policy for servicing non-low income people. You can use up to 10% of the amount planned for your tribal program years for families whose income falls between 80 and 100%, okay, of the median income. HUD approval is required if you plan to use more than your 10% authority, and that's what they call it. And somebody should always be tracking your 10% authority within your admissions department, okay? So you can't exceed that 10% authority without HUD's approval, or you try to assist a family with an income of over 100% of median income. Non-low income families cannot receive the same amount of benefits provided to a low income family, okay? The amount of assistance for a non-low income family will be determined as followed. Remember, I told you there's a different calculation. The rent, including homebuyer payments under a lease purchase agreement to be paid by a non-low income family, cannot be less than the income of your non-low income family at 80% of median income. The rental payment of the family at 80% of median income, but it need not exceed your fair market rent or value of that unit. Other assistance, including down payment assistance for non-low income families, cannot exceed the income of a family at 80% of median income divided by the income of a non-low income family multiplied the present value of the assistance provided to that family at 80% of median income. And that's confusing the way that reads in my eyes. So I have it broke down somewhere later that I'll show you. A lot easier to follow. Calculating assistance for non-low income families. To determine your fair market rent for your area, you go to www.huduser.org, the data sets. The requirements set forth in that section do not apply to non-low income families that recipient has determined to be essential So you know, when you deem somebody as essential, you don't have to charge them more. They don't charge against your 10% authority either, okay, if you make that determination. Guidance on calculating down payment assistance, monthly rental payments, homebuyer payments are provided in Appendix 5. And you should have that non-low income assistance policy that I said, you know, that I was just referring to. So the ATIHA will provide assistance to non-low income families to the greatest extent feasible, you know, in accordance with NAHASDA. The policy describes the exception to the non-low income requirement whereby non-low income families, Indian families, can receive assistance under NAHASDA. The method for determining and documenting when housing need cannot reasonably be met without NAHASDA assistance. Okay. The process for ATIHA to request HUD approval to assist non-low income Indian families is also described. Applicability is to all non-low income families requesting housing assistance in any of the ATIHA 37 housing stock homes or housing assisted with NAHASDA funds. NAHASDA assistance to non-low income families will be made available under the following circumstances subject to the availability of funds. Conditions specified within the Indian Housing Plan under the following circumstances. When a total of 10% of the total grant funds for a given IHP are designated by ATIHA to be available for assistance to families whose incomes are between 80 and 100% of median income. When you have a HUD-approved model activity to provide assistance to moderate and income or above income families, or other conditions which non-low income Indian families can receive benefits under the IHBG program include the following: loan guarantee activities under Title VI of NAHASDA and Title VII. So in order to provide assistance to non-low income Indian families, certain conditions must be met. In all cases, ATIHA must determine and document that there is a need for housing for each family which cannot reasonably be met without assistance. So that's why I said if your tribe offers a program of non-stock homes, or you have fair market housing or anything like this, you're going to be hard pressed to make this determination or this statement, okay? Because you do have another way to serve those members. You must state in the ATIHA IHP that it intends to use up to 10% of its annual grant amount to assist those families that fall between 80 and 100% without HUD approval. HUD approval will be required if you plan to use more than your 10% authority, or when you plan to provide assistance to a family with an income over 100% of median income. In these cases, it would be considered a model activity, and that model activity would be required to get that HUD approval. A non-low income Indian family cannot receive the same benefits provided that you provide to a low income family, okay? You have to make a determination of need for housing which cannot reasonably be met without your IHBG assistance, inadequate housing, housing that's not safe, physically sound condition, all systems performing for their intended use, not adequate space or privacy for all your household members, temporary housing or homelessness, cost burden, inaccessibility to financing, you know, basically the same things you're going to have for your essential families placement. And then you have to make that determination that that housing cannot be met without that assistance. Income and assets, that there's no private and government programs that can help them, the housing market conditions, that are no units around, the location. Now that particular statement there will help sometimes make this determination. Housing location for families who reside within the reservation or the Indian area and would not consider moving from the reservation or the Indian area. The ATIHA need only consider the availability of housing on the reservation or the Indian area when determining if that housing need can be met without that IHBG assistance. We have people that have never left our reservations. We shouldn't force them off, but it's dependent upon the policy that your tribal governance rights or you put forth before them, and overcrowded conditions. So your assistance policy, you have to have that documentation of the need, supporting that, property inspections, a statement for temporarily housing facilities. So this policy spells it all out. Rejection letters, poor credit does not itself constitute a need. Copies of tax returns, a statement by the head of household explaining why they have that housing need. So this is all in there. Now, on to processing your verification, processing applications, your different forms of verifications, provisions for refusal to sign. Make sure you have that in there. People can't refuse to give you information. You're the one helping them. We have to try to get away from, we're here to do a service, but you're not necessarily entitled, but we are there for them. So it's a fine line. Managing your waiting list, selection, and occupancy standards. A&O issues for other programs, management, and compliance. Okay, so verification before selection can occur. Your admissions and occupancy staff should interview your applicant family, obtain current information about that family, the circumstances in order to prepare that verification process. At your interview, you need to confirm and update all the information provided on that application. Explain your requirements, your verification process, your penalties for providing false information. Obtain current family income, household composition information, and the other data needed to certify eligibility and compute the applicant's rent or homebuyer payment. In accordance with 1128, your staff have to verify that that family is income eligible based on that family's anticipated income. Those verifications must be retained in that residence file, as it's going to be reviewed during the compliance monitoring. Because recipients have flexibility in designing its programs, there may be program specific items that will need to be verified. Likewise, some items mentioned in Exhibit 6.1 may not be applicable. Whatever that situation, each program must be governed by policies and procedures applicable to that assistance. Sorry about the logical order, Dorothy Nix. It gets that way sometimes. Exhibit 6.1, eligibility for admission such as proof of a tribal affiliation, income assets and asset income, family composition, social security numbers, your recipient preferences, if you have any of those in place, such as tribal member preferences, other federally recognized enrolled members, program specific preferences, if it's a home buyer, home ownership program or a veterans program, your recipient priorities, if you're going to do income targeting or income tiers, or people that have never ever been served by your programs, or elderly or homeless, or displacement by a natural disaster or a governmental action or domestic violence. Deductions such as family members other than the head or the spouse or the co-head under 18, age and disability, family head or spouse, disability of family members, child care cost, unreimbursed medical, so those standard 5 we went through, recipient standards for applicant and selection criteria, landlord references, do you require them? Credit checks. I know housing authorities that run complete credit checks to see if it's going to be, was there a problem with bouncing checks? Were they, do they own a landlord 2 years back rent, their previous history of tenancy, their rent paying, how'd they care for that home, their utility history. Can they get utilities in their name? That's sometimes you will see people put that in their A&O policy, that the heads of household must be able to put utilities in their name. Makes sense. Criminal history on all your adult household members if required. A documented ability to abide by your recipient lease and contract requirements. I guess maybe they didn't before. So, other program requirements, if they're applicable, is it going to be emergency housing, congregate housing, special needs? Do they meet that criteria? Housing rehab, down payment assistance. So, you have to do the verification of that information, not income. For example, if you operate a down payment assistance program for low-income families, the level of assistance is $5,000 for any low-income tribal member who can qualify to purchase a home and meets the NAHASDA income qualifications. In this case, the recipient needs to verify the gross annual income. The factors such as displacement or disability would not even be a consideration. Exhibit 6.2 provides verification items specific to other programs. Your social security numbers, one of the most important tools for IDing an applicant's or their participants' social security number. Prior to admission, each family member who has a social security number who is at least 6 years of age is required to disclose and verify that social security number. Children whose behalf welfare benefits are paid have social security numbers. The best verification is the original social security card. If the card is not available, you may, as a recipient, accept letters from Social Security that establish and state the number. Documentation from another governmental agency could also or should also be accepted. Depends on your policy and the way your A&O is written. A driver's license, military ID, passport, other official document that establishes and states that number is acceptable. Michigan's driver's license don't have social security numbers, but apparently some states do. The document used to verify social security numbers should be copied and placed in that applicant's file. If your tenant needs an updated social security benefit statement, you can actually go online to the following link and request that a copy be sent to their home. So, you can request a benefit statement, but not necessarily the social security number itself. So if applicants state they don't have a social security number, you should ask the applicants if they have ever worked, had a bank account, received any governmental benefit, or attended school in the United States. If they respond negatively to those questions and continue to state that they do not have a social security number, you should have them sign a certification to that effect. You may not require an individual who does not have a social security number to obtain one. Most methods of verification require a social security number. So the recipient, you, should be familiar with how an applicant can obtain a social security number locally. Know where your office is, if applicants indicate that they have a social security number, but they can't verify it, the family cannot actually be assisted until that verification is provided. That's up to your policy. Applicants who have social security numbers but refuse to provide them are not supposed to be eligible for housing assistance. I'd call your HUD office. See, if a member of a tenant family indicates that they have a social security number but cannot readily verify it, he or she shall be asked to certify this fact and be given 60 days to provide the verification. If the individual is 62 or older, you can give them up to 120 days at the recipient's discretion. So, verification examples for other programs. Down payment assistance. These are just exhibits. Have they done 18 hours of home buyer education? Do they have 2 years of stable employment? Mortgage readiness? You got the appraisal ready? So you should have your criteria all laid out for your different programs. That's one of the reasons why it's really important to separate everything. You can keep it all in a big binder, but you should have your different policies and your different requirements for every program that you offer, okay? Types of verification to ensure that the data upon which a determination of eligibility is based is full, true, and complete. The information submitted by each tenant is supposed to be verified before any change or action can take effect. Complete and accurate verification records are to be maintained in the tenant's folder, although there are 3 types of verification that you as a recipient can pursue. Every attempt should be made to use third-party verification. I remember the first time young into this game, I was thinking, wouldn't first party be better than third party? But it's just the opposite. Third party is the best. Third party verification, if it's unsuccessful, the tenant file should be documented, describing the efforts and the result. All 3 methods are going to be further explained on your behalf. Housing staff sends directly to the source, and documentation is returned directly to the housing office. Third-party verification means the tenant doesn't touch it at all, okay? You're going to deal with their employer, and the employer is going to send it back to you. In the case of a tribe, where your tribe could be one of the biggest employers, make sure that you establish that relationship with your human resources, and that's what we used to do. Then we would just send, the signed release of information, and they would, send anything we would need. It's a lot quicker that way. Bring them to lunch sometime, or invite them up when you're having a staff barbecue. Make sure you have a good relationship if you're going to use them over and over and over again. So third-party verification should be obtained whenever possible. This type of verification comes directly from the income or the information source. Third-party verification should never be hand-carried by an applicant to be filled out. The applicant will usually sign the top portion of the verification, confirming their permission for that release of information. The form is then sent by the housing staff to the entity, verifying the information, and that entity returns the form directly to your housing office. Completed verification can be sent, email, fax, regular mail. It's important that the method of return delivery clearly indicates that it is being provided directly from the information source. If an employer faxes a completed employment verification form to the housing office, then the fax number, the date, the name of the sender should appear at the top of that fax. If it is sent via email, the cover email should be included and completed with that verification form. Original verifications that are returned via regular mail should have a housing's received stamp showing the date that it was returned. So keep that information in your record, just not that little portion. Remember, you have to make sure that they're eligible at the time of admission. Sometimes third-party verification is not filled out by the entity completing the form. When this occurs, clarifications can be obtained via the telephone follow-up. Clarification must be on a separate form or a memo, as the housing staff should never write on the areas of a verification form that are supposed to be completed by that third party. The clarification record should indicate the name of the person that you contacted at the company, the date and the time that you made that contact, the questions that you asked them, and the information that you received. The housing staff person who made the follow-up call must also sign and date that clarification form. Okay, so make sure you're doing the part right. Housing staff sends directly to the source. The documentation is returned directly to the housing office. Should be obtained whenever possible. That's the method you're supposed to try to use. Okay. Possible third-party verification sources can be obtained from, but not limited to, you can use credit bureaus, the Internal Revenue Service, federal matching programs for Social Security income, public assistance, social services, TANF, the employers, financial institutions, Bureau of Indian Affairs for credit and trust incomes, certificates of Indian blood, educational institutions, employment verification, GA benefit, child support, VA benefits. Those are just a few. Second party verification is to be used when you can't get the third, okay? Your policy has to address when circumstances can warrant your second party verification. You can require 3 attempts prior to accepting second party. In the event, documentation must be included in the file that all efforts were made and the decision to resort to second party verification took place. The following represents examples of second party documents: check stubs, Social Security award letters, and copies of tax returns provided by the applicant. In my mind, I never saw a problem with a legitimate check stub or a Social Security letter. But that's the rule. So first party verification is the least reliable for verifying household information. You may use documents submitted by the applicant when the information does not require third-party verification. Birth certificates, Social Security cards, tribal ID. Third-party verification is impossible or delayed for a considerable period of time. You can use notarized statements, signed affidavits, okay? Always try to get as many of your employees in your office as notaries as possible. It will come in handy. The tribe allowed us to pay for that on behalf of, we didn't make the staff members pay for any cost associated with becoming a notary republic. And we offered those services to any of our tribal members, but it comes in handy. Try to get a couple of them because everybody gets a day off. It's very, very helpful. Such certifications are authorized alien certification or asset disposal. Other preferred methods can't be obtained where family's income is derived solely from cash transactions or through barter, and to document lack of income. So a copy of those documents should be kept in that file. Later, if they become a resident in the resident file, it should include a memorandum issued by your housing employee when that third-party verification was not possible. So your timing of your income certifications. Your households that receive assistance have to be income eligible at the time the assistance is provided. So I kind of went through this. Some programs allow a 60-day period. I always, 30 is too long in my mind, but establishing a deadline for formal eligibility determinations is a challenging part of your planning process. The certification, the formal determination of income eligibility must be made shortly before they receive that assistance, because eligibility determinations involves verification of income. Waiting too long can delay the assistance. Conducting income certifications too early in the process, however, might mean that those certifications became too outdated and must be redone. So, as an example, a recipient could allow verification within 60 days. So just make sure you think long and hard about that. Don't let it be too long. So they don't say, were they eligible at the time? You did that 3 months out. Verification forms. When verifying information, your staff should develop standard professional looking forms. There's always somebody, I'm a speed reader, okay? There's always somebody in your office that you should be sending your stuff through to make sure you start typing, you get tired, something happens, have somebody look at your stuff to make sure that it is looking good coming out of your office. I had to do that because I had some girls that like to make forms, but their typing abilities weren't that good. So you have to make sure it's professional looking coming out, develop standard professional looking forms requesting all that information that has to be verified, consent to release information, which provides a useful tool for acquiring necessary information. Consent forms must be signed by the head of household, regardless of age, spouse, co-head, regardless of age, any other occupant who is 18 or older. You should almost be trying to find out. I'm a big proponent of 5-year calendars for your staff, by the way, so you can time out things. But when your people are going to turn 18 and they're still in the house, they need to sign those forms for you. Standard verification forms include, but are not limited to, consent to release information, verification of employment, income, trust income, savings, pension, and landlord verification. Ask the applicant to sign multiple copies of each verification form. If the third party misplaces the first copy, immediately forward another request for information without obtaining another additional signature. Alternatively, a clause can be included in the verification form in which the applicant provides permission for the use of copies. Make sure it says that if that's what you're going to do. Send self-addressed stamped envelopes with the request for information. And I don't know if I put this in this one, but that standard HUD form that we all use? That expires in 13 months. And I don't mean down at the bottom, the form expires. I mean, their signature is only valid for 13 months. So every time that they come into your office, make sure during the recert or whatever, they're signing a new form for you. Make personal contacts with major employers, public agencies for which your, tenants can receive income. Your casino or, the big employer in town. Give the family an opportunity to explain any significant differences between the amounts that they report and the amount reported by the third party. They said they made $9,000 a year. You get the verification and it says they make $23,000 a year. What's up? So. Provisions for refusal to sign. Make sure this is in your policies also. If the applicant or tenant, any adult member of the applicant or tenant's family, do not sign and submit consent or verification forms as required, denial of assistance may be exercised or will be exercised depending on how you want to word it. If the applicant or tenant, any adult member, does not sign and submit, denial of assistance can be exercised. So your waiting list, once an applicant is determined to be apparently eligible to receive assistance pursuant to your policies, that applicant's name is placed on your waiting list. The waiting list is the mechanism used to implement the preference systems, establishes the order in which housing assistance is offered to the applicants. Setting up and maintaining the waiting list properly is essential to carrying out your admissions in accordance with program regulations and policies. A well-organized waiting list is also a source of data about the need and demand you have for units by size, type, and location. The waiting list can be closed if the number of applications greatly exceed the amount of available units. Your organization, they should include the following topics: essential application information required for waiting list placement, preferences and priorities within those preferences, opening and closing your waiting list as applicable, waiting list organization. Are you going to do it by location, by bedroom size, by program type? Entering your new applicants, updating it, removal from that waiting list, making and rejecting offers and reporting. Making and rejecting offers. So you have to, I think I discussed this a couple of days ago. Make sure you have your policies outlined, how many times they can say, I'm sorry, I'm not ready to move yet. Just keep me at the top of the list, or just keep me on the list. So, how many times are you going to let them refuse your offer? And are they going to go to the bottom of the list? It's got to specify what you're going to do with them. Removal from that waiting list. Do not remove somebody from your waiting list unless actually they ask you to do it and you can get it in writing. It is the way, because I've seen it questioned, and HUD will question your waiting list. Why did you take them off? So whenever you remove anybody, you better have the documents proving who did it, why they did it, when they did it. Okay. And they might come in, 4 years after that employee is gone. So make sure it's right. Your preferences, the admission policies can include preferences, or just make it so only your ED can move somebody from your waiting list. Your admission policies may include preferences which do not guarantee admission, but rather establish the order of placement on your waiting list. Assigning preferences to applicants who meet certain criteria is a method intended to provide housing opportunities to applicants based on, their household circumstances. Take a good look at that. some of the policies that I've walked in on just came right out of the book, and from years ago, the book from 1940 or 50, it seems like. Well, the first house was in 61, so it was after that. But make sure that those are truly your preference. Do you have anybody displaced by natural disasters? If that's on there and you've never had somebody in 30 years, take that preference off. Make sure that it's, something you can live with in this day and age, and that your preferences and your priorities are truly what they are. Okay. Applicants with preferences are selected from the waiting list. They receive an opportunity for an available unit earlier than those that don't have that preference. Preferences affect only the order of the applicants on the waiting list. They do not make anybody eligible who is not otherwise eligible, and they do not change an owner's right to adopt and enforce tenant screening criteria. Recipients identify available preferences, give applicants an opportunity to show that they qualify for that available preference. Don't just believe somebody's a vet. You're going to have proof of that if you're giving a veteran's preference. The preference specifically identified under NAHASDA allows you to give preference to your tribal members first. Okay, that's how it should read. We're going to give preference to all Bay Mills members first. Any other federally recognized tribe, however you write that. In providing housing assistance, Exhibit 7.1 provides an excerpt from a recipient's policy regarding tribal preference. Tribal and Indian preference. Notwithstanding the other provisions of this section or this policy, the any Tribal Indian Housing Authority will give preference in the admissions to members of the respective bands of the any tribal Indian tribe of somewhere. The order and application of these preferences shall be set forth elsewhere in this policy. Okay. Preferences. Other examples: length of residency in the Indian area. Are you going to let somebody that's never lived on your reservation take, precedence over somebody that's been here their whole life, and on your list for 10 years? Mortgage readiness, elderly native, homeless native, students native, person of disability native, native veterans. Those are all different preferences. Priorities. The admission policies may also identify priorities within your program preferences to ensure consistency with your specific program requirements, to correct any inequities, such as families who have never been assisted versus those who previously have. Exhibit 7.2 provides examples of priorities for a lease purchase program. Lease purchase program can establish priorities, including but not limited to, first-time homebuyers, length of stable employment, creditworthiness, affordability, savings. Placement on the waiting list. You must review each completed application received, make a preliminary assessment of your family's eligibility. Placement on the waiting list does not indicate that the family is in fact eligible for admission. A final determination of eligibility and qualification for preferences will be made when the family is selected from the waiting list. The admission and occupancy policy has to identify circumstances under which an application is considered eligible to be placed on the waiting list. A common practice is to consider only completed applications. That's what I did. This makes sense for large housing programs because of the huge demand for housing assistance. However, incomplete applications must still be reviewed in order to identify missing information and tracked. The admissions and occupancy policy should address how incomplete applications are handled and the applicant is notified. Okay. I also had a form that they had to sign telling me this is where I'm supposed to be reached. It's up to me to come in and tell the housing authority if I move addresses, because this is where they're going to send everything. And I had them sign it with their address on it. So that's how I had a method to send anything back, to get a hold of them. And they can't come back. I got really tired of coming in and hearing, well, I didn't get that. I moved. Well, did you tell me you moved? You think I'm psychic? Yeah, you got it. So I had that form and they signed that form, and I made sure that they know, okay, we're going to keep this in your file with your stuff. This is where everything is going. And you have to come in and fill that in person, so that's what we did. So just to make sure, and then you outline if it's not complete, we're going to hold this for, 3 months, and then we're going to put it in the inactive file or whatever period of time you have. Always, though, when it's missing information, put it in writing what you need, okay? They'll forget. They're upset when they get there sometimes, or they get shook, or, I need the birth certificates for these guys. I need this signed by this one. I need, I need your tribal ID, copy of your tribal ID for your husband, or, so give them it in writing. So placement on the waiting list, if it appears that they're likely to be eligible, you can send a written notification of the family's placement on the waiting list. I don't do that. I did not do that. I wanted to make sure that that whole package was complete before we put them on a waiting list. The notice will indicate the waiting list preferences for which the family appears to qualify. The recipient must place on the waiting list families for whom the list is open unless the recipient determines the family to be ineligible. Where the family is determined to be ineligible, the family must be notified in writing. Yes, when you run a criminal history or for whatever reason that you deem a participant because of a household member or whatever ineligible, you have to send that in writing. And your policies should say, we're going to send it in writing within 7 days. Now, I walked in and seen somebody said 3 days. Okay, so you deemed him ineligible on a Friday. Monday was a holiday. Tuesday, you've already hit your 3rd day. So make sure you have a significant, a larger amount of time to make that. Just in case it's a holiday or whatever. Make sure you classify business or calendar days, okay? On all your policies on things like that. So that notice will specify the reasons for ineligibility, due to a criminal, something revealed within your criminal background. And inform the family of their right to request an informal hearing or grieve it, and explain the process for doing so. It's good to practice updating your waiting list annually by contacting applicants to confirm the information is still accurate. I had right in the policies, that it is good for 1 year, to reaffirm they're still interested in the housing assistance for which they applied. If staff determines the applicant is no longer eligible or the applicant requests to be removed, staff should document this and remove the applicant from the waiting list. Be careful with that. Okay, like I said, nobody should just be arbitrarily removing somebody. We would ask them, could you please put that in writing that you would like to be removed from the list? If they don't have an ability to do that, you make sure that your staff, they called at this date and asked to be removed. And then you have the staff member sign and date it and put it in that file, okay? Waiting lists can be maintained manually or in an automated system. Primary advantages of automation: quick manipulation of the large amount of data, greater objectivity. However, the data is only as good as the staff that's inputting it. So selection. Section 207 in NAHASDA describes tenant selection criteria for housing. Tenant and homebuyer selection: the owner or manager of the rental housing assisted with grant amounts provided under this act shall adopt and utilize written tenant and homebuyer selection policies and criteria that are consistent with the purposes of providing housing for low-income families, are reasonably related to program eligibility, ability of the applicant to perform obligations of the lease, provide for a selection of tenant and home buyers from a written waiting list in accordance with the policies and goals set forth in the Indian Housing Plan for the tribe that's the grant beneficiary of such grant amounts, prompt notification in writing to any rejected applicant of that and the rejection and the grounds for that rejection. So required topics: income eligibility requirements, Indian preference requirements, other preferences and priorities, definition of family, project specific eligibility requirements. If it's an elder project, They have to be 62 or older, whatever you put in place there. Project social security number requirements, income limits, procedures for accepting applications, selection from the waiting list, procedures for accepting applications and pre-applications, procedures for applying your preferences, including income targeting if you're doing it, your selection criteria, if you're going to require drug-related or criminal activity criteria, other eligible screening criteria that you could put in place, procedures for rejecting an ineligible applicant, your occupancy standards, your unit transfer policies, including the selection of in-place residents versus an applicant on the waiting list when a vacancy occurs, Section 504 of the Rehabilitation Act requirements and the Indian civil rights laws and statutes, policy for opening and closing your waiting list for that property, applicant notification, opportunity to supplement information that they've already provided, procedures for identifying applicant needs for the features of accessible units or reasonable accommodations, policies for notifying applicants and potential applicants of changes in your tenant selection plan, and your tenant selection plan. You have to develop and make public a written tenant selection policy and procedure that include descriptions of the income and other eligibility requirements that must be met for admission. Exhibit 8.1 provides a sample outline of the areas that a tenant selection plan should address. And your selection criteria. Selection criteria for tenants and home buyers are established by policy. Examples of permissible criteria: demonstrated ability to make monthly rental home buyer payments on time, to be a good customer and a neighbor, comments from current and prior landlords, credit references, housekeeping habits, criminal background checks to document illegal drug or, drug use or criminal activity, units which are handicapped accessible, reasonable accommodation to disabled applicants, consideration of extenuating circumstances, use and necessity of assistive animals. There is criteria which is prohibited. You can't make them take a physical examination. Examination or medical testing may not be required as a condition of admission. Pregnant applicants may not be required to undergo medical testing to determine a child's sex for assigning a bedroom size. All applicants may be uniformly required to furnish evidence of ability to make obligations of tenancy, but a greater burden may not be imposed on individuals with handicaps. Persons with handicaps may meet the requirement of occupancy with the assistance of others, such as an attendant care provider. Disability status, except for units specifically designed for individuals with disabilities, where an applicant requests a unit or a preference, it's unlawful to make inquiries to determine whether an applicant for a dwelling unit, a person intending to reside in that dwelling unit after it's rented or made available, or any person associated with that person has a disability, or to make an inquiry as to the nature or severity of the disability of such person. Rental selection score sheet, okay? This is a sample. Local area bonus points. Enrolled tribal member family living in the community, 25 points. Head of household. Is there 2 enrolled members? 1 head of household enrolled, member of a federally recognized tribe. Children. Any enrolled tribal members? Members of federally recognized tribe. Do they have references? Do they have an employment history? Do they have housing counseling? So some people use these selection score sheets. You don't have to, it's up to you. 3 years employment. This could be for the lease purchase program. Meets minimum incomes for debt service, mortgage ready in 3 years, so that's up to you to put together with your governance boards. Overview of your selection process. Generally, the steps in the selection process. An applicant provides that application, which gives you enough information to determine their eligibility to receive housing assistance in order to be placed on that waiting list. When the unit becomes available, The top applicant on the waiting list is notified of pre-selection and asked to come in for an interview to collect and make sure all their information is current, make sure they're still, you think within your income limits. During the verification process, the staff will determine if the applicant still meets the qualifications for that specific program. Once the verification is completed, eligibility is confirmed, an offer of housing assistance is extended, and if it's accepted, you'll assign them that unit. Don't let them move in or give them the keys until that unit is ready and all your paperwork is done. Okay. You can't, once you do something for one person, you're supposed to be able to do it for everybody. So systems, there's my warning. Many systems for selecting participants have been developed to ensure fairness, prevent conflict of interest from occurring. Methodology chosen for your recipient has to be established in your policy. Some of the selection methods include, but is not limited to, some people do it by lottery. First come, first serve. Some use a point system. Some use that sample selection criteria sheet using that point system. Okay. Your selection process, your staff verifies all the information and determines your income and program eligibility. After determining that criteria for selection has been satisfied, your housing staff will proceed to your final selection and move in. Once that determination is made, that written notice should be mailed to your family. The notice should include at least the following: a description of the determination, a time frame for the receipt of your response that they have, to get back to you that they want it, a description of a hearing appeals process if you've denied them, or, if an applicant rejects 2 offers, your policy could require that they be removed from your waiting list for a specific period. Some people do that for 6 months, or some just drop them to the bottom because the list is so long. Your selection process, upon the availability of a unit, the staff would select an applicant from the top of the appropriate waiting list. Some housing programs select the top 2 applicants, just in case that first one decides they don't want it. Generally, the following selection procedures apply. You send that invitation to your top family, depending on where you're at. If you're a small reservation, they pick up the phone and they call them. Respondents submit that notice of acceptance within a prescribed time frame, typically 14 days from the date of the pre-selection. The staff requires meetings with the family to provide orientation, update them about their updated information and their verifications. So your occupancy standards. Unit size is one of the most difficult aspects of selecting a family for housing, determining the appropriate size of that housing unit, because the number of the family members will increase or decrease over time. My people that were in my mutual help units for 3-bedroom homes, some of them there's 2 left. It may be necessary to anticipate the size of a family to avoid having to move them into a larger home if they're a young family. However, it's never appropriate to place a family in an overcrowded situation in anticipation of the family size decreasing. Okay. No set requirements for specified in NAHASDA or HUD as to what unit size should be assigned to a family at the time of move-in. Consider developing occupancy standards for determining unit size at move-in. In doing so, think about the number of the people in the household, children expected to be born, children who are in the process of being adopted, children whose custody is expected to be obtained by a member of the household, live-in attendants, children who are away at school but live with the family when school is out, families requiring additional bedrooms due to health or medical conditions, possible growth potential of the family in a home ownership program, somebody who, has notoriously been a foster parent for your tribe for years. The general guidelines you should follow, determining how many persons can share a bedroom or whether the person of an opposite sex can share a bedroom. Developing standards consider the size of the unit, the number and the size of the bedrooms. Determine whether children of the same sex can share a bedroom. Consider where when reasonable to do so, the number of persons in the household, the relationship and the sex of the people. Consider whether the number of persons required to share a bedroom should be limited. Those are all things that you have to consider whether unrelated adults and the persons of the opposite sex other than spouses should be required to share a bedroom. We would never do that. Consider whether a child can be required to share a bedroom with a parent depending on the child's age. Those are all things that people have asked over time. Consider whether it's permissible to provide additional bedroom space for others who are not members of the household, such as adult children who are active military duty or visitors. To avoid overcrowding, it's advisable to match the family size to the bedroom size of the homes in accordance with your locally established occupancy standards. Such standards could be waived when necessary to achieve or maintain full occupancy. Exhibit 9.1 shows you typical standards. And this is, 1 bedroom, 1 person, 2 bedrooms, 2 people, could be a dad with a daughter, so this is one of the sample occupancy. So your A&O issues for your other programs. The course provides comprehensive coverage of standard admissions in your occupancy programs governing your low rent assistance. Those policies apply to housing programs in general. Recipients have created additional programs which generate unique requirements, which can include NAHASDA enabled activities such as down payment assistance, closing cost, tenant-based rental assistance, housing rehab and assistance, homeownership loan improvement assistance, mold remediation, weatherization, emergency assistance. And there's some sample policies that are actually in the appendices for that. Your down payment assistance. Recipients operating down payment assistance program have to establish policies governing the eligibility of your participants, the delivery of assistance. Regardless of the content of the policy, the first order is to determine income eligibility. In addition to the basic admission requirements, down payment assistance programs are developed by you as a recipient based on the needs of your tribal community. In designing a program, your recipient should consider, the number of families who can qualify, the grant assistance. Is it a loan? Are you going to require it to be paid back? Availability of housing assistance or housing stock and new construction in the area. Your area's economy, your affordability ratios, your mortgage financing lenders. Do you have anybody that's going to lend on your reservation? Do you have 184? Your useful life, you have to make sure that you have those requirements met. So when using NAHASDA funds, there has to be a binding agreement in place to comply with our affordability requirements, which defines the period for repayment or recapture of funds based on the amount of funds invested in that home purchase. The example below outlines a recipient's approach to useful life. Program Guidance 2020-02, and in Appendix 8, and we have Appendix 8A also, both talk about useful life, and they've got some samples in there, okay? Exhibit 10.2 provides sample eligibility criteria for a down payment assistance. So per unit investment, 5,000. The recapture period would be 1 year. 5 to 10,000, 10 years. 10,000 to 15,000, 15 years. 15 to 25, 20 years. This pretty much matches the useful life stuff that is in the guidance there. Okay. So your categories, the purpose to address your tribal community needs, your eligibility requirements, your income and your affordability, your housing counseling. Are you going to require that? Could include credit repair, home buyer ed, debt management, your selection criteria. First qualify for the mortgage, the financing. First served in line is how you're going to do it. Eligibility property type, as long as it's in standard condition. Your property value. Established cost limit. You could apply a total development cost. Your maximum assistance for a low-income family, in this case, would be $10,000. The maximum assistance for a moderate income family, you use that HUD formula to calculate that max assistance because you can't give them the 10,000. So you establish all this criteria for each program that you offer. And my thing is not showing me. Sorry, guys. There we go. Lease purchase program. Let me check because I don't want to make you go too long. There's more pages to this one than I thought. Okay, I'm going to stop where we're at. And I will put this in tomorrow's, okay? I did make an extreme amount of time to catch us up. So does anybody have any questions? A cheat sheet?
Yes, sorry. It's been glitching a little bit, so if I cut off, Crystal is here to pick up where I left off. But yes, we do have some questions.
Okay.
I am just gonna put the survey in the chat real quick while I tell you the questions. For those of you who would like to answer the survey, it is greatly appreciated. Okay, the first question is Alma. When we talk about regulations, the word may still shows there is a possibility. Do you mean may as in shall? They shall not be eligible?
It depends on which regulation she is talking about. If it's 200, they don't use may anymore, they use shall. So it's going to depend on every circumstance. That's why it's so important that you need to learn how to use those 3 documents, because each one of them will refer back to a number where you can quickly go and read the rule as it applies to that, to make sure that you know the difference.
Hi, this is Alma. Yeah, I was just, that was my question. It was referring back to partially the beginning when you were speaking about uh those it would be the head of household, the spouse, or there was one more person not being or may not be eligible for financial aid. So that's what I was referring to on that question when it came to it being may not be eligible or shall not be eligible. Yeah, I'm just so used to reading other regulations, local agency, affordable housing, government.
Right.
So
Yeah, absolutely. On those ones, those if I have it right to where you are in that record, yeah, I don't think it was financial assistance. I think it was a deduction, an allowable deduction, and it applies to the 3, the head of household, the spouse, or the significant other.
okay, yes, that's correct. Yeah.
Okay. And depending on where you're at in that point in time, it's only allowable if you sit in one of those 3 positions, or in some cases, like in the amount of a school, to count somebody as a deduction. If they are in that, they're not allowable. So I would have to point you back at that regulation. I'm sorry, because unless I see it, or if you want to tell me what slide it is, if you send me an email and I'll figure it out and send it to you.
Oh, yeah, no problem. I mean, if we if I can get back to where we were, we were still covering parts of, I think, day 3. So this was early, very early on.
Yep,
But
yep.
if I find it, I'll send it. But I understand.
Please do.
where you
And
are.
like I said, you're going to get that over time. And I answer my email unless I'm teaching. I usually try to get an answer to somebody within a day. So
All right. Thank you. I
please
appreciate
do not
you.
feel, reach out to me. There's no problem with that.
Okay.
Okay.
Thank
What
you.
else do we have, my girl?
Okay, question number 2 is from Stephanie. I thought the social security cards were to be kept in a locked cabinet separate from the tenant file.
That is up to the policy of your housing entity. Some programs require that, some don't. It depends on what you've done with your personally identifiable information, what rules that you've put in place. Okay. So some people still keep them.
Okay, and then Bessie also has a question. She says, home buyer receives Social Security. His adult son lives with him and is a student and also a full-time employee. When the son's income cannot be counted, they are under the income guidelines. How could we count the son's income in the situation?
I think this is the same one she asked about yesterday. And I told her to, because I don't have all the things, she has to call the HUD office. The home buyer receives Social Security. His adult son lives with him. So do you have him as a co-head in that house? I don't know that because he's an adult son. And the Social Security, is he disabled, making him, I don't know the circumstance. That's why I'm saying, so usually you just count that first 400 of his income. And then the rest of his income you don't count. But if he is considered in your paperwork the head of household, a co-head, then you have to count it. So like I said, I don't know. But from the way it sounds, he's not the primary leaseholder. So you would count the first $400 of his income, and then the rest you don't count.
Okay.
And I
Because
don't know if
she said no.
Right. Like I said, she's going to have to call and explain that to somebody at the HUD office. I can't do that via this.
Okay. And then
Okay.
Dorothy said to that he would be an HOH since other is disabled, but you're saying to still go to the
Yes,
HUD.
definitely.
Okay.
Because you don't necessarily, just because the father is disabled, make a, is he a 22-year-old son? Do you put him on the lease and make him head of household if there's nothing wrong with the dad except that he's got a disability? I don't know the circumstances there. So, and no, there's no cheat sheet for the whole shebang. There's just a copy of the whole PowerPoints you get. That's as much of a cheat sheet as I can give you.
Okay. Well, thank you so much, Cheryl, for today's presentation. If there are any other questions, please go ahead and comment them in the chat box. I'm going to go ahead and wrap up. We are going to continue tomorrow, part of day 4, and then jump into day 5. We will start again at 2 p.m. EST. Sorry, what was that, Cheryl?
Nothing.
Okay. We will begin tomorrow at 2 p.m. EST. If anyone has questions, please put them in the chat box. Dorothy just said, I think EWONAP has one.
Okay, so the other thing is I'm going to try to get everything in tomorrow, so if we go 10 minutes late, we're going to go 10 minutes late. I'll give you a heads up, okay? But hopefully we'll be done on time. So thank you, guys.
Thank you, everyone, for joining us. I'm going to put in the survey one last time. We do appreciate everyone filling out the survey and letting us know how we did, and I hope you enjoy today's virtual training.